2 stands part.
Chairman.
Phil Twight.
One of the first cases of leaky homes that I had contact with after becoming an MP was a very, very unfortunate development called Pepperwood Mews, and the building still stands actually. It's on Great North Road in Kelston, now in Carmel Cipolloni's electorate, and it had been a development that Housing New Zealand undertook in the mid-2000s. And Waitakere City Council was the local authority that signed off the work. But basically what Housing New Zealand did was they did a deal with a developer and said, we'll sell you this land, and if you develop it, we guarantee that we will lease all of the dwellings from you. And it's basically a block of apartments. And the developer built the building and sold off the individual units to a whole lot of mum and dad investors who ploughed their retirement savings into this development. It was the most shonky, most dodgy, rotten development that you could imagine. And within about 3 or 4 years of being completed and signed off by the local council, Waitakere City Council at the time, the place was basically condemned. It was uninhabitable. It was leaky in the extreme. And since then, since about 2010, I think it was, that building has stood a sort of a rotting hulk on Great North Road.
Order, I sort of regret interrupting the member. I'm sure there is a way of tying his story into the part of the bill. But after being going for nearly 2 minutes, I'd appreciate him doing that just to show that he is being relevant.
Very important, Mr Chairman, to provide some colour for the discussion of part 2, because...
that would be nice too.
So part 2, I think, is the other part of this bill that deserves some specific comment in this debate. And what it does is basically provides, again, it's a pretty technical minor tweak that will that basically responds to a decision by the Supreme Court that basically said that that it's all around the definition of the word built. So let me explain that, if I may. So to have a claim declared eligible under the Act, claimants must meet a series of statutory criteria, and we've discussed that in relation to part 1. But those criteria include that the claim must be made within 10 years of the date on which the affected structure was built. What is the meaning of built? So it's very vague, if you think about it. And until the case in question, at the Supreme Court, Osborne versus Auckland Council 2014, until the case was decided, basically the interpretation of the word built was essentially the finalising of the building, and what the Supreme Court held was that the meaning of the word built in this case would be the issuing of the code compliance certificate. And the Osbornes, not the Osbornes from television fame, but the Osbornes basically took this case through and John and Helen Osborne of Auckland had been arguing that the 10-year limitation on leaky buildings basically should start when the code compliance was issued, not when the physical building had been completed. And they took it all the way through to the Supreme Court. The commentary at the time said that the effect of the ruling could mean that another 300 leaky homeowners could benefit from the funding assistance package. So I don't know what has happened. This was a year ago now when the Supreme Court handed down that judgment. I don't know what's happened since. I don't know what's happened to the Osbornes. It would be interesting to know whether John and Helen Osborne have in fact sought to be registered under the funding assistance package and to get the benefit of the scheme. So that's basically what it does, and the effect of Part 2 will be to slightly increase the pool of eligible homeowners.
Poto Williams.
Thank you, Mr. Chair.